Good afternoon, boys and girls. Someone was kind enough to give me, this is for Maddy Madness Constitutional Corner. This is her motion to dismiss information and vacate arrest warrant. Now, I will say that this is written by an attorney. So that's awesome. Eric J. Friday, Esquire. And I am going to be critical of this, but it's not because Eric Friday did a bad job. I want to be perfectly clear about that. There are times when, you never get the perfect client. You never get the perfect case. If it was the perfect client with the perfect case, then that client would be charged. You know what I mean? It's either, if you're a defense attorney, you get a client where there is a reasonable question of fact or law, generally speaking. I mean, I'm sure there are some. There are a few motions to dismiss that do work. So a reasonable question of fact or law where it can go either way. And or it's just a loser, or it's just a straight up loser. And again, unfortunately for Maddy, I think that this one is a straight up loser for her, mostly. But we're going to go through it, you and me, and baby makes three, I guess. And we are going to see what she does and what she doesn't do right in this. And it's not her, it's her attorney. I understand that. But for my intents and purposes, it's her. So defendant Maddy moves to dismiss the information filed against her in this case, and as grounds, therefore, states, number one, the statute under which defendant has been charged, section 934.03, subsection 1A, Florida Stat, has been previously construed as unconstitutional as applied to defendants similarly situated to the defendant here. See Bacon versus McKeithen at 2014 U.S. District Lexus 197381, 8-10, Northern District, Florida, 2014. Officers lacked expectation of privacy when recorded by a citizen. So we're going to look at Bacon versus McKeithen, but we're also going to look at the Florida statute first. And this is what she's charged under. The interception and disclosure of wire, oral, or electronic communications is prohibited except as otherwise provided in this chapter by any person who, A, intentionally intercepts, endeavors to intercept, or procures any other person to intercept or endeavor to intercept any wire, oral, or electronic communication, right? So that's the starting point. So she's being charged with 934.031A. But in order to understand that, they're using three very specific terms: wire, oral, or electronic communications. What are wire, oral, or electronic communications? Well, did I not do the right thing? I did not do the right thing. And I want to go to here, and I want to go to here. A wire communication means any oral transfer made in whole or in part through the use of facilities for transmission of communications by the aid of wire, cable, or light connection between the point of origin and the point of reception, including the use of such connection in a switching station furnished or operated by any person engaged in providing or operating such facilities for the transmission of intrastate, interstate, or foreign communications, or communications affecting intrastate, interstate, or foreign commerce. So this is a wire communication. This means something that is over the phone. Just for ease of purpose for here, a wire communication is a phone call situation. An oral communication means any oral communication that's not going over the wire. It's oral. So if you and I are talking in the same room, we're having an oral communication, right? An oral communication means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation and does not meet and does not mean any public oral communications uttered at a public meeting or any electronic communication. So what's the difference between a wire communication and an oral communication? Well, obviously, if you're going to record a wire communication, you're recording a phone call. You're recording a phone call. That's it. You're tapping into the phone call, maybe putting it on speakerphone and clicking record on your wire, or excuse me, on your tape recorder device. Maybe it's more. Maybe you're running it through a computer, or who knows? Maybe you just have an app on your cell phone that allows you to record it. But you're recording a phone call. An oral communication, recording oral communications, is where you're talking to someone face to face, and maybe you have a wiretap on you, or like a body camera or something, or a hidden camera or hidden microphone on you. And think of it like the informant, where the police tape the microphone to your chest before they send you in to talk to the bad guy. That's an oral communication. It's a face-to-face kind of communication. But notice how they're treated differently. An oral communication requires that the person who's uttering the communication have an expectation, a subjective expectation that such communication is not subject to interception. That language is not present up here in the wire communication portion. And the second thing is, down here in oral communications, it doesn't apply at a public meeting or electronic communication. So right now, we know that Maddy recorded a phone call. So we know that we're going to be dealing with a wire communication and not an oral communication. And then electronic, mechanical, or other device. An electronic communication is just basically anything that isn't an oral or wire. Here we go. It's basically any kind of communication that isn't an oral or wire communication. Okay. But really, these are the two big ones. These are the bad boys right here. And we know we're not dealing with an oral communication, and we are specifically dealing with a wire communication. I know that was a long detour, but he's sending us to look at Bacon versus McKeithen, where officers lacked an expectation of privacy when recorded by a citizen. So we're going to go to Bacon versus McKeithen. And this is Bacon versus McKeithen. There you go. This is what he's referring to. There are other ones out there where it's actually McKeithen. It's McKeithen's motion. But this one is theirs. And it's the 20-page long one, not the 11-page long one, that has the language that Maddy's attorney is quoting. So down in here, he deals with the Florida statute. Okay, now, in this particular case, what Bacon did is Bacon got pulled over by a cop. Oh gosh, I should go back up there, right? So it's a traffic stop. And Bacon recorded the stop on his cell phone. So what do we have going on here? We have an oral communication, because Officer Chad Vidrine pulled over Bacon, and now they are having oral communication. And Bacon is recording it surreptitiously. So the questions, obviously, that the court is going to have are, does Officer Chad Vidrine have a reasonable expectation of privacy that his conversation is not going to be recorded? And is this a public meeting? Those are really the kinds of things that we have to deal with on this one. And the court doesn't really address those, but we'll see what it does. So as a matter of first impression, I, meaning the district court judge, construe Florida statute 934.03 to be inapplicable to Bacon's conduct because the officer did not have a reasonable expectation of privacy. Did you see those magic words? He did not have a reasonable expectation of privacy. If we go back up into here, we see that he is looking at this. No reasonable expectation of privacy. The officer made a stop in public in an open area where bystanders could have been listening to his conversation. Further, video cameras in police cars routinely record traffic stops. And no one knows And one who knows they are being recorded cannot have any expectation of privacy. So the video camera in Vidrine's car was recording it, so there's no expectation of privacy. Likewise, there's little societal expectation of privacy for officers acting in the line of duty in public places. Notice all these words. There's little societal expectation of privacy for police officers acting in the line of duty in public places. An expectation of privacy in these circumstances would undercut societal expectations of police accountability. So there are other cases that go on to say that there has to be, for these oral communications, there has to be a subjective expectation of privacy by the person whose utterances are being recorded. And there also has to be a societal expectation of privacy in those circumstances, something that society is willing to say should be private. So, for example, if you go into someone's office with an expectation to commit a crime there, intending to commit a crime there, your utterances in that office aren't protected because society doesn't protect people when they go into. Anyway, you get my point. I've read a bunch of cases and I don't remember what exact one it was, but society has to have an expectation, or society has to be prepared to recognize that right of privacy. This expectation is corollary to the constitutional right to gather information about what public officials do on public properties, and specifically a right to record matters of public interest. Most importantly, any contrary construction of the statute would raise serious constitutional issues as to its validity as an unreasonable restriction on constitutionally protected speech, and I will construe ambiguous statutes to avoid constitutional problems. So, as you see here, this is what he just read, or this is what he is citing. Number one, finding that to interpret it, it would raise serious constitutional issues. Now, he says up in here that it has been construed as unconstitutional, and we just saw that it is not. He said, I will construe ambiguous statutes to avoid constitutional issues. So he goes on to explain what would happen if in fact this statute did apply to recording the police. Recording a police officer is constitutionally protected speech subject only to reasonable time, place, and manner restrictions. If the statute were interpreted to forbid recording police officers during routine traffic stops, then it would be a time, place, and manner restriction on constitutionally protected speech. The state would need to show that it does not restrict speech substantially more than necessary to further a legitimate government interest, and it leaves open adequate alternative channels of communication. So that's what the state would need to show if the state were to continue on and say that 934.03 applied to recording police officers in the performance of their duty. That's what the state would need to show. Such a law, so applied, would be unlikely to pass constitutional muster. He doesn't actually say it will fail because that's not before him. At this point, the government has little legitimate interest in casting a veil of secrecy, blah, blah, blah. Such a restriction would also fail to leave open alternative channels of communication. In making this determination, I find persuasive, yada, yada. I therefore interpret the statute not to include recording police officers in public during routine traffic stops. So we already see the attorney flailing. I didn't say failing there, I said flailing. He is trying to grasp at something that is going to support his position. Because, I mean, what else is he going to do? He's taken Maddy's money. He's got to give her the best defense he can. So this is where we're at. He says, additionally, this is number 2, the 11th Circuit Court of Appeals has held that the definitions of Section 934.02 Florida statute must be considered in determining whether an alleged victim has a reasonable expectation of privacy in an anticipated prosecution under Section 934.03. You see McDonough v. Fernandez, Rundle, and there's a citation for it. Well, again, we're going to have a problem. Is this McDonough? I think it is. Yes. So this is McDonough v. Fernandez Rundle. And in this one, the big thing is that McDonough lodged a series of complaints, and he was invited to a meeting to the chief of police's office to discuss the complaints. So what do we know? Number one, it's going to be an oral communication. And number two, he was invited to a meeting. He was invited to a meeting in the police officer's office, or in the chief's office, to discuss the complaints. Now, how many people constitute a meeting? I don't know. I don't care. Is there a reasonable expectation of privacy in the police chief's office when he invites people there to discuss complaints? I don't know, and I don't care, because those things are relevant to oral communications. The person has to have an expectation of privacy, and it can't be uttered at a public meeting in order for 934.03 to apply. So again, we know that McDonough v. Rundle doesn't, what is it? McDonough v. Fernandez Rundle is inapposite. It does not apply. You're looking at oral communications when you're dealing with a wire communication case. This is a specific case where the facts matter, because the facts are going to determine which statute to apply. In this case, the alleged victim, Ms. Howard, is a public official and a records technician who accepted a phone call from a member of the public and a citizen of the state regarding a matter of public interest, a public records request. Now, I am not entirely sure. I mean, he just asserts that this is a matter of public interest. I'm not entirely sure that it is a matter of public interest. Just because it has to do with Maddy's case or whatever doesn't make it necessarily a matter of public interest. But he asserts it, so that's fine. But again, we know that it doesn't matter what her subjective expectation of privacy is, and it also doesn't matter whether this is a public meeting. So this is fluff right here. While Ms. Howard may have a reasonable expectation of privacy in a workspace away from the public in a secure facility, that reasonable expectation cannot extend to a phone conversation from an incoming call on a matter of public concern. See Bacon and McDonough. Again, those apply to oral communications. In McDonough, the police chief invited McDonough to a meeting. In Bacon was pulled over on the side of the road. Neither of those is accepting a phone call. Imagine if all that had to happen to have no expectation of privacy, not that that matters, but imagine if all you had to do was answer the phone. Then that would entirely gut the statute. The statute 934.03 934.03 requires, oh boy, I think it's 2D. I don't remember where it is in here. It is lawful if everybody agrees. Somewhere in here. Here we go. 3D. It is lawful under these sections for a person to intercept a wire, oral, or electronic communication when all of the parties to the communication have given prior consent to such interception. Now, this has been changed. When it was first drafted, all the way through, I think somewhere in the 60s, it was only one of the parties had to agree to it. That's all that was required. One party to agree to it. But they changed it. They changed it to require that all parties give consent. Now imagine what would happen if every time you answer the phone, all of a sudden you no longer have a reasonable expectation of privacy. That would just strip away that protection. So, I mean, I think it's about the best argument he can make, but it's not a good argument. I mean, there's no real good argument for him, unfortunately. The only basis for not having such calls recorded where matters of public concern are involved is to not take such phone calls for a public records request. And I don't know exactly what he's arguing here. There's a footnote: a refusal to accept public records request by phone call would likely fail to give effect to the public policy and intent. So what it sounds like he's saying is that like the state is basically caught between a rock and a hard place. They have to accept these calls, and if they don't accept the calls, then they're not giving effect to the Sunshine Statute. This isn't very well worded. I don't understand what he's going for. I really don't. Where FHP chooses to situate its public records custodians or officials accepting calls for public records requests is beyond knowledge of the public and is FHP's own decision. By its own admission, it does not allow members of the public into the space. This argument and distinction is irrelevant to the issue at hand. By Maddy's attorney's argument, yes, it would be, because anytime anybody picked up the phone, I mean, you've just basically waived all of your right to privacy. And I'm not entirely sure that FHP has a real strong argument there either, that the location of the person is a requirement, because again, the statute does not require for the wire intercept an expectation of privacy. For the wire intercept, it's just you can't intercept it unless both or all parties consent. It's the oral communication that requires the expectation of privacy. And since this was a recorded phone call, there you go. Were this a matter of defendant recording inside a secure facility, this might be a different case, but that's not what's being alleged by the state. And yes, that is an accurate statement. If Maddy were recording inside the secure facility, then it would turn on whether or not the state has the people being filmed, the people being recorded, whether or not they had a reasonable expectation of privacy, and whether or not that expectation of privacy is something that society is willing to recognize. And then you have to ask whether it's a public meeting or not. But that's not the case here. The suggestion in the initial media report that a member of the media or the public should be prohibited from recording a conversation with a public official carrying out their public duty based on where a state agency chooses to locate an employee's desk is beyond absurd. Well, yes, however, this is a Supreme Court of Florida case, Shevin versus Sunbeam Television Corporation and the Miami Herald Publishing Company. Now, these folks didn't like this new law. They didn't like it where it had to be an all-party consent state, because what they had done before is they had, because they were a party to the call, like if they were interviewing a public official or something on the phone, they wouldn't have to tell them, but they could just record the conversation because they're a party to it, right? So they didn't like this new law. And so they were arguing that testimony was produced displaying the value of concealed recordings in investigations of consumer fraud, housing discrimination, illegal abortion, corruption of officials, and various other matters. And the Supreme Court of Florida said, sorry. The legislative branch went through this and they made their decision. You can still write down what the person says. You can't record it. You can't record it without their permission. You can still write your article. You can still take notes. You can't record it. Shevin versus Sunbeam. The extraneous information contained in the warrant affidavit regarding Miss L'Angelaise, Maddy's prior interactions is irrelevant to the issues in this case. Its relevance to other issues, such as the state agent's dislike for Miss Longelet and her, I'm just going to call her Maddy, dislike for Maddy and her attempts to hold police officers accountable for their conduct is unmistakable. The extraneous information and this paragraph, they're both irrelevant. Neither are going to sway the court's opinion, unfortunately, for Maddy. Well, I'm assuming that, if my reading of the statutes are correct. What is made clear by the inclusion of extraneous information in the warrant affidavit is an attempt to influence and prejudice the court regarding Maddy. It also blatantly demonstrates that this is a political prosecution designed to limit the right of the public to obtain public records and hide FHP's potential attempt to avoid compliance with public records laws. Contrary to established Florida law, Ms. Howard told Maddy that her request would have to be made in writing. While the request for Maddy's name was not a violation of Florida's public records law, if Ms. Howard had refused to process the verbal records request unless Miss Maddy provided her name, that would have constituted a second violation. And okay. But again, that is still irrelevant to whether or not Maddy violated law. So again, 934.03 doesn't turn on the intent. It doesn't turn on the intent. It is just if you intercept it, if you record it, if you record a wired communication. I mean, there are some exceptions. There are some exceptions when you could do it, like if you're a law enforcement agent, if you're authorized by a law enforcement agent, if you have a court order. I mean, there are reasons to do it, but public records request isn't one of them. The inclusion of the extraneous information further demonstrates this prosecution as a retaliatory action against defendant for her activism, specifically the exercise of First Amendment protected news gathering, seeking to hold public officials accountable for their actions and conduct. And okay, the extraneous information also proves too much. I don't know what that means. By the admission that Ms. Howard's conversations could be easily overheard by multiple other individuals near her workspace, the state essentially admits that her conversation that was recorded could not have been with the expectation that it would remain private if numerous others could overhear it and be overheard during the call. Well, not really, because you're not getting the full phone call. Her coworkers were not hearing both sides. And her coworkers were not, I mean, the law doesn't prevent you from overhearing something. The law prevents you from recording it. So just the fact that there were people within earshot who could be heard, or other people on other phones could overhear what the person was telling Maddy, is not relevant. Without a reasonable expectation of privacy in communications, the prosecution of Maddy for recording the conversation fails as a matter of law. Again, the reasonable expectation of privacy is for oral communications, for recording oral communications, not for recording phone calls. Moreover, the idea that a member of the government tasked with public interaction could ever have a reasonable expectation of privacy in such communications would run afoul of Florida's broad policy of government in the sunshine. Again, reasonable expectation of privacy is not relevant. A failure to dismiss the information in this case would have a chilling effect on all citizens who attempt to record and document the actions of public officials. Yes, as far as over the phone, that it probably would, unless you say, hey, I'm recording this call, and they say okay and choose to continue. But yeah, you can't record in Florida. It's an all-party consent state. You can't record it without all parties consenting. While the legislature is certainly entitled to pass a law that prohibits the surreptitious recording of individuals in circumstances where they have a reasonable expectation of privacy, prohibiting such recording of public officials in all circumstances, as argued by the state here, would be unconstitutional. Again, it's not all circumstances, it's over the phone. I'm assuming the state is arguing that you can't record a phone call. Excuse me, you can't record a phone call. And yeah, that's what the statute says. And this is State versus Walls. I just figure I'll throw this in here. Hence, the legislature has determined that as a matter of state public policy that the right of any caller to the privacy of his conversation is of greater societal value than the interests served by permitting eavesdropping or wiretapping. Any. It doesn't matter if it's the state or if it's a private citizen. Any caller. However, the state has not passed an unconstitutional law in this case, most likely. The legislature, which is contrary to what he was saying above, that part of it was found to be unconstitutional, the legislature has specifically exempted from inclusion in 934.03 oral communications, those made at a public meeting, oral communications. If we go back, I know I'm beating this to death, but this is important. These are the statutes. These are the minor little things. Wire communication is over the phone. Oral communication is in person. While the statute does not define public meeting, the McDonough case is instructive. Not really. The 11th Circuit held that even in a meeting with a private citizen and even before the inclusion of an uninvited citizen, there was a public meeting where the topic of discussion was possible police misconduct. And it doesn't actually say that. And I don't have that marked, so this is going to take me a minute. McDonough was a member of the public who attended the meeting at Chief Roll's invitation. The public nature of this meeting became, this is language that the attorney, Eric Friday, is relying on. The public nature of this meeting became all the more evident when Chief Rowley allowed Livingston, a second and uninvited member of the public, to attend. So it became all the more evident. It doesn't mean that just two people is going to make a meeting. Because just imagine that. Well, first of all, the statutes exempts public meetings, right? It doesn't mean like a meeting held by the government. It's a public meeting. So if you and I go to a secluded area of the park, we're in public, right? Could I still have a reasonable expectation of privacy? Sure. Would it be a public meeting if there's only two of us? I think that tries to stretch the terminology too far. But when you go back to this case, when you start off at the very beginning, Chief Roll invited McDonough to a meeting in his office. So just the very nature of it, and the fact that the chief of police had a lieutenant there, I believe. So there were 4 people present. Would it have been a meeting with only 3 people present? Maybe. Would it have been with 2 people present? Maybe, but that seems to be pushing it quite a bit. 19. The probable cause affidavit describes and alleges that A, the call occurred on a government phone. Okay, a government phone was called. Claims that Howard did not grant permission for a recording. Permission is not necessary if there's not a reasonable expectation of privacy. That is not present in the statute. He is confusing oral communications and wire communications. The area is not accessible to the public, a demonstrable falsehood since a member of the public's voice and hearing accessed the space with the full knowledge and permission of FHP. That's not a very strong argument there. Admits that numerous persons not parties to the call would have been able to overhear Ms. Howard's side of the conversation. Again, not very persuasive. And again, it's irrelevant to the statute. Admits that the arrest affidavit was prepared in part based on the FHP attorney's opinion and legal analysis of the statute at issue. Well, yeah. Attorneys normally do give legal analysis. The affidavit concludes with disparaging characterizations of Maddy's constitutionally protected activities in an attempt to influence the court to take adverse actions against her for engaging in those activities. Well, I think what they're really trying to do is secure a conviction for wiretapping. Applications of facts to law. Ms. Langelet, Maddy has been charged under that section. That section requires the state to prove that she intentionally intercepted, endeavored to intercept, or procured any other person to intercept or endeavor to intercept, B, any wire, oral, or electronic communication. That is correct. But he needs to refer to, well, he didn't want to. He doesn't need to. Anyway. Apparently, while innocent until proven guilty, citizens have no reasonable expectation of privacy when forced in the back of a police car. Police claim a reasonable expectation in their headquarters, even when communicating with the public whom they invited in, at least in the auditory sense. So the police car is different. In the police car, there was a case I read on that. State versus Smith. Even though there are people who were put in the back of a police car and they were talking, but police cars have cameras in them that are going, they just do. I mean, we've all seen dash cams. We all know that they're recording what's going on inside. You should not have a reasonable expectation of privacy in the back of a police car. And it's different when you're calling someone. That person can expect that call will not be recorded unless you tell them otherwise. Regardless of any contrary claim in the arrest affidavit or information in this case, the state of Florida invited defendants' ears into the alleged private space for the purpose of discussing a matter of public concern, a records request for a public official's employee file for purposes of public reporting on that official. Again, not very persuasive. The fact that a state employee then attempted to circumvent public record laws by telling defendant you need to do that in writing, indicating requests had to be made in writing rather than taken verbally as required by law, is a matter of public concern. Sure, that doesn't, just because it's a matter of public concern doesn't mean you get to violate a statute to get it. This case should have never resulted in the issuance of a warrant or the filing of an information. I agree, but it's such a petty thing to do, but whatever. This case is nothing more than a blatant attempt to punish an individual for daring to investigate official misconduct and recording or efforts to do so when a second official, the alleged victim, attempted to illegally require that a records request be in writing and the defendant disclose her identity. The well-established principles of open records, freedom to record government officials, and freedom of expression by publicizing government's interaction with the public and how they perform their duties cannot rest on so slender a reed where every citizen must fear prosecution for documenting governmental misconduct, nor should individuals' constitutionally protected actions be included in an arrest affidavit in an attempt to influence the court. Wherefore, yada, 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 by Eric J. Friday. Valiant attempt by Mr. Friday. Honestly, I don't think that Maddy should be prosecuted under this. I really don't. It's so petty. It's so petty. I mean, who cares? It's not like there was anything really personal in it, but whatever. I mean, that's just my personal opinion. I've given you the legal analysis. Do with it what you will. I wish Maddy the best of luck. I'm not your enemy in this, Maddy, but that is my frank legal opinion on this particular motion to dismiss. I do not expect it to succeed. But, if it does, congratulations. And, I hope for the best for you. Thanks for watching. Have a great day.